It is irrelevant because it is the function of the court to draw inference and form its opinion from facts. The witness gives evidence as to the facts. The court forms its opinion from those facts. This is just a confirmation of my previous submission that I've just made, that this witness didn't have any insight as to relating to the facts. He didn't know what was going on. Maybe he was called to testify to confirm that the accused is competent to basically possess a firearm relating to accused number 2. So an issue that is not in dispute. We know he has all the required licenses. He's not being charged for that offense. I've already read the evidence relating to Section 22 and Regulation 21, what it states, but it's submitted that accused number 2, in his own evidence of this Mr. Wood, if he had insight into the facts and what had transpired from his own evidence, accused number 2, if you look at Section 110A, would have been guilty of an offense if the state had proved that he did indeed, if I didn't make that concession earlier, that the evidence is inconclusive of accused number 2 actually handing the firearm over to accused number 1. If I was able to prove that accused number 2 would have been convicted of a particular offense, if you look at Section 120(10) in brackets A. Insofar as accused number 2 is concerned, I've already made my concession relating to him, and that I did not prove the case beyond reasonable doubt, and that the video relating to him handing the firearm over to accused number 1 or vice versa is inconclusive. But I'm obliged as an officer of this court to direct the court of the provisions of Section 257 of the Criminal Procedure Act if this court is not in accord with the state's assessment of the evidence insofar as accused number 2 is concerned. Despite my concession, Your Worship, you might find otherwise that you might not agree what I have just conceded relating to accused number 2. That's why this provision will become important, and it's my duty to assist the court to look at this provision. The section reads as follows: if the evidence in criminal proceedings does not prove the commission of the offense charged, but prove that the accused is guilty of an accessory after that offense, or any other offense of which he may be convicted on the offense charged. I want to repeat that again, because I think accused counsel for accused number 2 and myself will have a disagreement only on this particular part. That is the decision where the court had to make efforts in KZN in order to collect these video footages, these recordings. They saw accused number 1 firing shots, several shots with 2 different caliber firearms during the EFF's celebrations. Samuel Kwata, Sibusiso Novo were present. They were the ones that operated this particular video equipment. They confirmed what they've seen on the video footage after the police visited. But according to the 2 of them, while they were there, they did not see accused number 1 firing any shots, because they did leave the video footage or the video equipment unattended at some point. Your Worship, I'm going to the evidence of Colonel Nkosiko Nsuku, who's also employed as a media liaison officer and testified that on 1st August 2018 he received a viral video footage depicting accused number 1 firing shots at the EFF's first birthday celebrations from Captain Juan Sandari, governor, who worked at the SPS provincial office in Bisho. He also observed the video footage that accused number 1, according to him, handed the firearm over to accused number 2 after he fired shots. He forwarded the viral video footage to the investigating officer, Colonel Rodney Swartboy. Colonel Swartboy then requested him to compile a report from all media coverages relating to this particular incident, which he did. If Howders and if Matthews counsel for accused number 1 put it to the witness under cross-examination, it was a toy or blank firearm. This witness testified that he observed muzzle flash emanating from the firearm, and in his experience that real firearms is the ones that fires or has this type of muzzle flash when it being fired. A warrant officer, Amanda Yvonne Steenkamp, is also a facial expert at the SAPS. On the 2nd of August, she received a sealed CD containing still photos of the viral footage from Colonel Swartboy and was requested to compare the images on the still photos with social media images of accused number 1 and accused number 2. She was able to see from the photos accused number 1 firing shots with a rifle and thereafter handing the rifle to accused number 2. She was able to identify the muzzle flash but confirmed that she was unable to confirm whether the firearms were indeed real or not. She positively identified the persons depicted on the still photos as accused number 1 and accused number 2. Bishop Sergeant Dwayne Francis, a member of the SAPS employed at the Digital Forensics section of the SAPS here in East London, testified that on the 1st of August 2018 he received an official handset from Colonel Swartboy and was requested to download the 2 viral videos from the handset. He thereafter downloaded it on a CD which is sealed. A copy of the CD was then handed to the investigating officer and the second copy to Captain Rian Botha. He did not tamper with the video footage while it was in his possession. Captain Rian Botha also confirmed is attached to the Digital Forensic section of the SAPS, testified that the following day, the 2nd of August 2018, he received a sealed CD containing the viral video footage and was requested by Colonel Swartboy to make still photos to be sent for facial comparison and identification. He was able to see from the footage how accused number 1 fired several shots with a rifle and thereafter handing the rifle to accused number 2. He noticed the muzzle flash but confirmed that he was unable to confirm the firearm whether it was real or not. He did not tamper with the video footage while it was in his possession. Then we deal with the evidence of Captain Governor Juan Sandari, who was employed at the SAPS as a media liaison officer in Bisho. She testified that on 1st August 2018 she received the viral video footage depicting accused number 1 firing shots at the EFF's first birthday celebrations from the national media database of the SAPS. She also observed accused number 1 firing several shots with a rifle and handing the firearm to accused number 2 after he was done. She forwarded the viral video footage to Colonel Mzuka and requested him to investigate the matter further. She also identified the muzzle flash of the firearm when the shots were fired. Under cross-examination, this witness was unable to state whether this was also a toy or blank, a movie firearm. This witness tested that she observed also muzzle flash emanating from the firearm, and in her experience, that real firearms have muzzle flash when being fired. Colonel Swartboy, basically, you worship the evidence of Colonel Swartboy, it was basically just to complete the chain regarding to the investigation and the collection of the firearm in dispute SP the 2.23 Norinco firearm, 223 Norinco firearm. He gave a background, what happened during the investigation, and how the investigation led to the matter being brought to court. The only aspect about his evidence, how he collected the batch of firearms, which included this particular firearm, SPA 249, and that all these firearms were sealed when he received it at the Brighton Beach Police Station in KwaZulu-Natal. He was also responsible for taking these firearms to the ballistic section of the Forensic Science Laboratory in Gqeberha. Swartboy testified that he did not tamper with any of the exhibits that included the video footages, the cartridge case, the Norinco firearm, while it was in his possession. Much was made about the fact that Colonel Swartboy did not testify regarding the fact that the members of the SCPS that was employed as close protectors of accused number one stated that they did not see accused number one firing shots on the day of the incident. Yoshibai submitted that all these witnesses that testified were good, honest, credible, and reliable witnesses. They did not go out of their way to falsely implicate any of the accused before court. The evidence were objective. That is basically my submission regarding their evidence. Yes, I'm going to deal with the evidence in the manner in which it was led in court, starting with the evidence of accused number two. We know accused number two did not testify and elected or utilized his right to remain silent. He did, however, call witnesses to testify on his behalf. Yes, when I start with the accused number two, to start off, I already conceded that the viral video footage relating to the transfer or the handing over of the firearm by accused number one to accused number two, I will concede that is not clear. As the officer of this court, it was my job